Welcome back, everyone. This is my second presentation here. And we are going to continue the topic we saw yesterday. So I invite you to kneel down for a silent prayer. Amen. So yesterday we talked about mainly the Sunday law. And how our understanding or our interpretation of it was wrong. And God, in the 2014 to 2019 dispensation, and through his messengers, led us to a better understanding of it. So this was internally. We understood that the Sunday law had to be understood in the context of our time and our society today. That we had to adapt and interpret correctly according to dispensations. But we were not the only ones with that issue of understanding the Sunday law. We are approaching the Sunday law. It's our waymark. That's what it's our whole main goal as in this movement, even as Adventists. And it's an issue both internally and externally. Because God deals with both the internal and the externally the same way. Both have the same test. Even though the material given to them to succeed on that test might not be the same. So if we have been facing that problem of interpretation on the Sunday law, internally, then should be the same externally. They should have that issue of interpreting correctly or not the Sunday law. We've talked and studied a lot about the Sunday law and how it's the test of equality. So we should see an issue of understanding about equality in general. Among the United States, we saw that. As they are the sixth kingdom of Bible prophecy today. So we compared the internal and the external, and seen how how that test played out. How, because of our misinterpretation of the Sunday law, we were misled on different topics. We gave the example of women in leadership and pants for women. And externally, we saw two main characters. In the United States, and how they were fighting for equality in their own ways too. We saw the example of Trump, who was for white supremacy and misogyny. Because he was going back to the beginning of America. Because why was he upholding that supremacy, that white supremacy? So let me rephrase that. Trump was upholding white supremacy and misogyny. And why? Because he was going back to the founding fathers and the beginning of the United States. He was fixed in the meaning of the Constitution and how the founding fathers saw America. Same thing for misogyny. And that could, like, we're going back to the beginning of the United States again. We can see that misogyny. But we could even go back the whole 6,000 years. And externally, the example we gave in this, we're focusing on this dispensation, last presentation. How their interpretation of the way they read the Sunday law, they understand the Sunday law, creates two classes. And externally, we talked about Ruth Bader Ginsburg, who was on the opposite side of Donald Trump. And was adapting. We read a quote that was taken from a video. Of something she said in 2008. Of how we have to adapt and include the groups that were not included at the beginning of America's history. This whole topic is what originalism is all about. I know we didn't properly define it. So that's what we're going to do today. Remember, we're talking about the Sunday law. how we understand the Sunday law, both internally and externally. And right now we're focusing on the external to see how they read the Constitution, and therefore how they're gonna apply or understand the Sunday law. We're gonna read an article. I'm not gonna read all of it because it's 13 pages. I will read some paragraphs and then make comments and summarize other paragraphs. But if you read it on, if you want to read the entire thing, you can read on the media broadcast. It's the first one that's Elder Perminder posted after Elder Tess went on a break. So right now, the originalism is all about how do you read. Which is our main question internally, but also we can see externally. And the article begins by saying that liberal lawyers should consider that issue of originalism. Because if they don't, they're gonna be trapped in the different arguments that originalists are gonna bring. So we're gonna give right now the definition of originalism. And explain, it's a really complex topic. So we are going to talk about the different types, if we can say, of originalism. But we won't be able to see all of them and to understand all the points it brings. I will let you study that on your own. So definition, quote 2 in my notes for the translators. It says, I will read the paragraph per paragraph. Originalism, the belief that the meaning of the Constitution was fixed at the time it was adopted, is the legal theory that dominates the thinking of this conservative Supreme Court. Not all of the conservative justices are committed originalists. I count 4 of the 6, all but Chief Justice John G. Roberts Jr. and perhaps Samuel A. Alito Jr., who describes himself as a practical originalist, but they have all written and joined originalist rulings. So 2 points here. First of all, So we're going to look at 2 points here. First of all, the definition in and of itself, which is that the Constitution is fixed from the time that it was written. Fixed, so I'm going to say fixed when written. And then it talks about, and remember, I'm going to change my thoughts. Remember, I told you yesterday that when we read this article, I want you to picture in your mind that this article was written and is something written about the movement. You replace all the judges and politicians with people in the movement and leaders, etc. And you replace the Constitution by the Bible. And you find the same thing, fixed in its meaning. The two groups. And this idea of dispensationalism opposed to a document that is fixed when it's written. So that's the point about the definition. I know it's quite a short definition, but I think it's efficient. It's going to be, definition is going to be added as we read the article. And we saw it yesterday with what Ruth Bader Ginsburg said. That she did not believe that the Constitution was fixed. Otherwise, that would mean that Black men Native Americans, Indigenous Americans, and women would not be included because they were not included when the Constitution was written. So there's no evolution. Then another point that is brought up in this first paragraph is how the Supreme Court is composed, what it is composed of, and how they are siding or not with originalism. So in the Supreme Court, you have 4 of the 6 who are committed originalists. But all of them have somehow joined originalistic beliefs. Which means that the decisions that are going to be taken by the Supreme Court we should find in them originalistic results or findings. There's also a different term that is brought up. The idea of practical originalist. This is one of the types of originalism that we're going to see. So we're going to read next paragraph. It says, given that reality, liberals can't lightly dismiss conservatives' insistence that the Constitution should be interpreted based strictly on the original meaning of its text. In the current circumstances, liberal advocates appearing before the court would be remiss not to make an originalist case. So here they're telling us that liberals have to be careful and have to understand that originalism is always going to be present in court cases. Especially in big court cases that relate to state and the country. And they should know how to respond to it. So next paragraph says, but there's also little evidence, at least in the highest profile cases, that it will do them much good. When originalist arguments favor a result the conservative justices dislike, they're content to ignore them or to cherry-pick competing originalist interpretations that comport with their underlying inclinations. Originalism doesn't serve to constrain, but to justify. This is not a fair fight, nor an honest one. So there's this idea of cherry picking. You just pick what interests you in the tree. And I think that's something that we can really see internally when we consider the Bible. I don't know if you've already tried. Okay. I don't know if you've already talked to someone who doesn't agree with dispensationalism. And maybe you've tried to explain to them why it's true. If they don't agree with the like slavery and sexism and how it's in dispensations, I like to go back to a simpler example. That's an example I generally give them. Which is the story of the tabernacle and the sacrifices. It was dispensational. It evolved. It didn't, like, we're not doing sacrifices of like animals today. And yet God was asking them to do so. But their understanding and their time changed. And what I generally see as a response to that argument is they agree with that argument, but then they cherry pick what they want to apply that to. If, for example, slavery, it doesn't, they don't like slavery, they're going to agree that it has to be dispensational. But when it comes to sexism, because they're sexist, they're going to find arguments to not use dispensation for that case. And that's what this paragraph is telling us for the Constitution. Originalists don't, they use originalism to agree with the answers they want to see. So that it can justify it. Next paragraph. And it is one with dangerous consequences. The more liberals present originalist arguments, the more they legitimate originalism rather than refute it and offering a compelling alternative. Courtroom advocates need to win the case at hand, yet that undermines the more critical long-term effort to wrench the court away from its reliance on what is, at least as currently practiced, a flawed doctrine that peddles the illusion of impartiality in the service of a conservative result. So originalism it serves the conservative. And we will see later that's the relation between the two. The next paragraph is explaining to us a little bit more about what is originalism and why did it start? It says, because originalism purports to freeze our understanding of the Constitution as written at the end of the 18th century or amended in the second half of the 19th, it is skewed to a cramped reading of the document, unleavened by modern science and sensibilities. Why should we understand, much less accept, the constitutional meaning as fixed at a time when women lacked the right to vote, when recently enslaved Black people attended segregated schools, and when the economy was agrarian, and when the notion of gay rights was unthinkable? So here, it adds to what we were saying, that the Constitution is fixed in its meaning. Whether it was when it was written, 18th century, or when the different amendments arrived in the 19th century. And it says here that understanding of the Constitution is supposed to be unleavened by modern science and sensibilities. So they don't want modern science and society in itself to trump or to modify what the Constitution would mean. So there's that idea of no new meaning. And it says that if we have to accept it, it means that we, as Ruth Bader Ginsburg said, it means we have to put away women, Black people, and gay rights. Because they were not present when the Constitution was written. Paragraph 7 says, one prominent recent example of those flirting with originalism involves the newest justice, Ketanji Brown Jackson. She says, I believe that the Constitution is fixed In its meaning, Jackson said at her confirmation hearings in March, "I believe that it's appropriate to look at the original intent, original public meaning of the words when one is trying to assess, because again, that's a limitation on my authority to import my own policy." So when she was when she arrived in office, I think maybe we read her speech, maybe we didn't, but we heard about it. And if we don't know what originalism is all about, well, maybe we've missed that point that she was making. But it's quite important to understand it, and to understand that there's a reason why she was confirmed in her seat. Is because obviously justices will prefer someone who's like-minded. And I honestly, I didn't pay attention to that part of her speech. And if I had, maybe I would not have understood how originalism really, how to say that, plays an important role in the decisions in the Supreme Court. She talks about original intent. I wrote it here. And we'll look more at it when we will look the different types of originalism. We're going to skip to paragraph 14. The different paragraphs before talk about what different politicians say about originalism. So now it's going to talk about how why was originalism developed? Originalism was a fringe legal theory when it was developed beginning in the early 1970s. It arose in reaction to the perceived excesses of the Warren Courts, which had worked a legal revolution in the 1950s and 1960s with freewheeling decisions on the rights of criminal defendants, civil liberties, and voting rights, among other issues that conservative critics said were grounded in the majority's policy preferences more than in the Constitution itself. So here it explains kind of how originalism began. So it was developed or created in the 1970s. Because the Warren Court wasn't liked by conservatives. And that the critics, conservative critics, didn't like it. Because it started bringing in different rights, such as voting rights. And conservatives were thinking that the court was taking those decisions because it wanted to. And not because it was based on the Constitution. They could not see the evolution of the Constitution. And once again, originalism is there to help conservatives fight on a decision on the point. So when they saw that what the Warren Court was doing, they didn't like it. They had to come up with an argument to respond. And originalism began. For the Constitution. And then it says that the judge has to stay close to the text. That it should not construct new rights. And I think we can all see that they're trying to come up with anything just to go against the Warren Court. It's really to serve conservatism. Because conservatives do not serve originalism, if I can say it that way. When originalism conservatism doesn't serve originalism. And by that, I mean that if originalism the points that it makes doesn't fit for conservatives, they're gonna let that go. Originalism is there to help conservatives when they feel like it. When it upholds their points. Paragraph 18 is going to start talking about original intent. And it says what began as a hunt for original intent evolved in a search for original public meaning, after adherents recognized that different founders had different intentions in writing and ratifying the document. But the stated goal remained the same: to provide a supposedly neutral guide by which judges could reliably interpret the Constitution and avoid substituting their personal views. By the 1990s, originalism was the interpretive approach broadly endorsed by the conservative legal movement. So here we can see two branches that start to divide. We have original intent, which is what the founding fathers meant when they wrote the Constitution. But even those people realized that the different founders had different interpretations and intentions. They do not have one rule. Like they realize that their methodology, I'm going to rephrase, their interpretation of the Constitution was not consistent. So they had to invent that idea of original public meaning to better fit their beliefs. And then paragraph 19 says, it would take decades longer for originalism to gain more than a minor toehold on the high courts. The year before Bork was defeated, Antonin Scalia, another originalist, sailed through the Senate confirmation process by the vote of 98-0. Democrats had decided to train their fires on defeating the simultaneous elevation of William Rehnquist to be Chief Justice. Scalia was joined in 1991 by Clarence Thomas, who outdid Scalia in his originalist zeal. I'm an originalist, but I'm not a nut, Scalia said of the difference between himself and Thomas. So here we can see that it takes time for this belief to really enter the Supreme Court and be used in court cases. Paragraph 20 says, but the pair remained on the edges of the court's jurisprudence. It was not until the Trump administration and the addition of 3 justices schooled in the originalist traditions of the Federalist Society, Neil Gorsuch, Amy Coney Barrett, and to a lesser extent, Brett Kavanaugh, that a powerful originalist bloc coalesced. So if we were to illustrate the rise of originalism, roughly, I'm not going to do a scale illustration of it. Started in 1970. And it's gaining some power, but not that much in the court. And then there's an event that's going to make it really rise. It's Trump. And the different judges that he's going to bring. It's quite interesting to see that it falls into that time period. Because we're talking about the Sunday law. Internally, we are asked to reconsider our interpretation of the Sunday law. To interpret differently the Bible. And externally, in the same time, they are faced with the same problem of how to interpret the Constitution. Paragraph 21, I'm just going to read the first sentence and the last sentence of the paragraph. It says, originalism may not yet be the undisputed law of the land, and last sentence, nonetheless, its emergence has been remarkable and its influence impossible to overstate. Paragraph 26. So it talks about different justices, which is not the point I want to get into. I want to understand what they say. So I'm going to read, which is precisely why it was taken up by Mies and company. They embraced originalism because it was conservative, said Michael Waldman, president and chief executive of the Brennan Center for Justice and author of a forthcoming book on the court. They didn't embrace conservatism because it was originalist. That's what we were talking about here. They're using originalism because it serves conservatism. They're not conservative because it's originalistic to be conservative. That's originalism is a tool conservatism uses it's something that they use when it fits and helps them. They let it go when it doesn't help them. So it's not an almighty rule that they go by. Paragraph 31. I could read more, but I'm going to summarize a bit. Paragraph 31. It talks about another form of originalism. Practical, I don't think we'll be able to read the paragraph. I'm going to explain practical originalism. It's when it's basically what originalism is. You use it when it's practical for you to use it. When it's a practical situation. I'm not going to go deeper into that. Paragraph 31 says, in recent years, one new weapon has been added to the originalist arsenal called corpus linguistics. It uses large database of documents from the relevant historical periods to conduct computer searches of keywords and phrases to determine their original public meanings. This technique has the advantage of moving the debate beyond competing dictionary definitions, and courts have started to employ it in both statutory and constitutional interpretation. So here it says that they go back to the original meaning of the word back then. They're going to use the dictionary of back then. They will use the dictionary that the founding fathers were using. An example that is given in the next paragraphs. Judge Catherine Kimball Mizell, which she was against the Biden mask mandate during COVID. Because he was saying there's a law saying that we are forced to wear that mask for sanitation. And she went back in that area of the founding fathers to look what sanitation meant. And sanitation back then meant it was more meaning a measure to stay clean. Yeah, she did. She said that in sanitation there was nowhere a mandate, an obligation. Therefore, she was refusing it. The mask mandate. So it's all about how do you read? And we do that technically in the movement. I was quite, when I read that, I was like, we do that a bit. We go back to Strong's dictionary to better understand the word that is used. But the difference, if we do that and what the judge was doing with COVID mask, is that when we do that with Strong's, for example, the Strong's dictionary, and we understand what a word meant back then, we still need to adapt it for us today. Sure, we understand now what the word meant back then, but it doesn't mean that we're going to literally apply it today. And that's what originalists do. There's no evolution in their words. When they use corpus linguistics. So we talked about how the different, we talked about how originalism has played a big part in the court cases. And the different examples we can take and that are quoted in that article is, for example, Brown versus Board of Education. So we have Brown versus a board. And paragraph 50, I'm just going to read the sentence. The first sentence, it says, adherence to originalism arguably requires, for example, the dismantling of the administrative states, the invalidation of paper money, and the reversal of Brown versus Board of Education. Next paragraph. So remember we talked about the Warren Court. the Warren court, the court with the Judge Warren, where originalism was created. And Brown versus Board of Education happened when Warren was a judge. And that court obviously was non-originalist. And I quote from paragraph 31, where Warren writes, Warren says, in approaching this problem of Brown versus Board, we cannot turn the clock back to 1868 when the amendment was adopted, or even to 1896 when Plessy versus Ferguson was written. We must consider public education in the light of its full development and its place in American life throughout the nation. Only in this way can it be determined if segregation in public school deprives the plaintiffs of the equal protection of the laws. So basically what he's saying is adapt. Use dispensations to interpret. You can't stay fixed in the meaning of the Constitution. And then other court cases are talked about. We won't be able to enter them. Such as Obergefell versus Hodges. Which talks about same-sex marriage. And some originalists are going to use originalist beliefs to support gay marriage in this case. Which means that originalists will agree to gay marriage. And they're going to say that their beliefs is based on the Constitution when it was written. But in that case, the author of the article, it says that it's you need to twist the Constitution so much that in this case, like, the doctrine of originalism has no sense. There's no point in being originalists if you twist it so much. to finish, we're going to read paragraph 74. I'm going to read the first sentence. It's not entirely comfortable for judges to acknowledge that they bring their own experiences and values to bear in deciding a case, but there is also no way around that truth. So here it says that the different judges who accept originalism want to keep the Constitution pure. And therefore, they don't want to bring their own experiences and knowledge. But yet, in that question of how readest thou, we have to bring our knowledge of today, our evolved knowledge, whether it's of the Bible or the Constitution. And that's the problem with Protestants and America in general today. They do according to their morality, their culture. We see there the culture and states problem. And because they want to uphold their certain morality and their certain beliefs, this poses a threat to the social advances that happened. Remember, we said that the Sunday law will not be amended, but it's going to be interpreted differently. The Constitution. And if it's not amended, it means that we're not going to see a change suddenly in the law. But the Constitution will be interpreted to bring in the same result. And another example of this here, and of originalism and interpretation, is Roe versus Wade. It was revoked without the Constitution being amended. Their interpretation changed it. So it will be the same for the Sunday law. We can see that the Sunday law is all about how you interpret it. Whether it's internally or externally. And today we saw the external aspect. Through originalism, which interprets it to have no new meaning. And therefore rejects any evolution or advances. So I hope that those two studies about what originalism is can better help you understand the Sunday law, its issues, and how we are facing the same problem internally and externally. Today we have to answer, how do you read? How do you interpret? So I invite you to finish and kneel for prayer. Dear God, we thank you for this day. We thank you for this camp meeting so far. I pray that you may continue to be with us and help us to take time to understand these events, because they are linked closely to our lives. It's how we're going to be able to see if we still have issues with equality or not. I pray that you may bless each and every one here. And help us to learn and better be able to teach also. And to put in practice what we saw in this camp meeting. I pray in Jesus' name. Amen. Thank you all for your time.